You start a lawsuit by hiring your attorney, paying a retainer, signing a representation agreement. In some cases, there is no retainer, such as in personal injury cases that are handled on a contingent fee basis. The structural way in which the case commences is that the lawyer will draft what is called a complaint. And this is the document that sets forth the facts of the dispute and the legal grounds for recovery. The complaint is filed with the clerk of the court, and the clerk of the court issues what is called a summons. The summons is the paper that tells the defendant you have been sued and you have 20 days to respond to this complaint. Small claims court is a little bit different process. Let's stick to county court and circuit court. The summons, as I say, tells the defendant you have 20 days from the time the process server or sheriff's deputy serves the complaint and summons on you to respond. The defendant must respond to the complaint by either filing an answer or a motion attacking the complaint saying that there are technical defects in the complaint. The answer goes through each factual allegation or element of a claim in the complaint and admits, denies, or says that you're without knowledge of that statement and therefore deny that statement. If the defendant fails to respond to the lawsuit within 20 days, a default will be entered. You lose by default, and then there is going to probably follow a judgment being entered against you without you ever having your day in court in a trial. The judges are randomly assigned to the case. They administer the case and rule on pretrial motions, such as a motion to dismiss or what is called a motion for summary judgment that can end the case without need of a trial. They move the case along to trial, conduct the trial, and they render a judgment based upon the evidence presented when a jury is not involved. When a jury is used, it decides the key issues, but the jury and the judge may each make rulings that decide the case. Motions to dismiss and answers, as I've said, are those things that respond to the complaint. In the answer, you can also raise what are called affirmative defenses. These are legal justifications that say the plaintiff may be right about what he or she is saying, but for legal reasons, I am not liable on this claim. The classic example is the statute of limitations, where you have waited too long to prevail on your case. You've waited too long to sue.